David Roebuck was called the Ontario Bar in 1970 and practiced with Laskin and Calvin, as it then was, until 1979. He went on his own, the harbinger of what many are doing now, in 1979, and now practices in partnership with the law firm of Roebuck Garbig. He instructs in civil procedure in the Bar Admission course and is formerly the Ontario chairman of the Civil Litigation section of the Canadian Bar Association. David?
Thank you for that warm introduction. Ladies and gentlemen, I find it difficult to talk generally about some of these issues after you've had this morning's discussion with the judges, but I want to start my remarks by observing that in the trend that I see from my perspective as a litigator is that in the law of employer-employee relations, more of the cases are being decided on equitable than contractual grounds, and my topic has a great deal to do with restrictive covenants, essentially contractual issues. But I think, as you'll see from the paper, should you choose to read it, that many of the issues are equitable, and the trend, I think, is in part because the court in this area has an overriding desire to do what they feel is just in the particular circumstances, and restrictive covenants, I mean, any contract is a straitjacket, but a restrictive covenant is a particularly tight-fitting straitjacket, and the courts, if they can find a way of doing justice as they see fit rather than the contracting parties see fit, they will do so. Policy considerations are looming larger, as the Hodge case illustrates, and policy is not as hidden as it used to be in employer-employee cases. And it seems to me that, well, freedom of contract has a nice ring about it and is a wonderful 19th century concept. In the area of unorganized employees, the individual employee facing the large corporate employer, freedom of contract is somewhat unequal. The unions fill the gap in areas where labor is organized, but the individual against the employer is still bargaining at less than equal status. And therefore, the desire of the courts to exercise their equitable jurisdiction where they can. In some instances, it's my personal view that there has been too much of a tilt in terms of expanding the net of fiduciary obligations. One example is that it's quite clear now, a number of cases have said that when a restrictive covenant fails, the courts may still impose fiduciary duties, but the way in which fiduciary duties are being imposed in some of the cases today seems to be a bit of a reach. In the classic case, Herbert, Morris, and Saxelby, the case that talked about the circumstances that underpinned an enforceable restrictive covenant, it was made clear that to enforce a restrictive covenant, you had to, against a mere employee, that employee either had to be privy to trade secrets or have some kind of personal connection with and influence over your customers. And unless you had that, you couldn't enforce a covenant even though the parties had sat down and made one. Well, in some of the more recent cases where there was no restrictive covenant, the court has looked to the fact that the employee had this type of personal connection with and influence over the employer's customers, and used that per se as a justification for imposing fiduciary duties, even though the employee would not fall into the category described by the Supreme Court of Canada in Canaro, the employees who clearly were well below top management. And I've argued elsewhere with great deference and respect that I think that trend is not correct, but it's symptomatic of the general tendency to cast the net of fiduciary duties very broadly and avoid the contractual straitjackets. Now, there are a number of topics that are addressed in my paper, and the time allotted to me and your collective patience wouldn't permit me to go through all of those points. So I've picked two of them that I personally find most interesting, and I hope that you'll share the interest. The two questions that I'm going to address very briefly are these. One, can a vendor of a business be prohibited from competing with his purchaser if the purchaser was foolish and didn't insist upon a restrictive covenant? And the answer to that seems to be a qualified yes. The second point that I'll discuss is this. Is it the law that a restrictive covenant contained in an employment contract necessarily fails or falls if the employee is wrongfully dismissed? And there, the answer is less clear. The limited case law in the subject would suggest that the answer is yes, but I will argue today that given a proper set of facts, a restrictive covenant may be enforceable even if the dismissal is found to be wrongful. First, dealing with the issue of sale of a business without a restrictive covenant. The historical case or the leading case rather, which discusses the interplay of covenants arising from employment per se and from a sale of a business, is the Elsley and Collins insurance case, a decision of the Supreme Court of Canada delivered in 1978. And in that case, the employee, the defendant sold the business and became an employee of the business. And he gave two covenants. One was contained in the agreement to sell the business, and one was contained in his employment contract. He was there for some time. The covenant contained in the sale of the business lapsed, but he was still an employee. He left, he went into competition, and the restrictive covenant in the employment contract came into focus. And in that case, the court discussed the different considerations that apply when there has been a sale of the business. And in particular, Justice Dixon gave a rationale for enforcing covenants which come out of the sale of the business by reference to the benefit of that covenant to the covenantor, to the vendor, the person who would be selling the business, because he noted that without such a covenant, a person might find himself with an unsaleable commodity if denied the right to assure the purchaser that he, the vendor, would not later enter into competition. So the point being made that these covenants aren't just for the benefit of the purchaser, a protection from competition. It's for the benefit of the vendor to be able to assure that the value will be there, and therefore you get the value when you sell the business. And that rationale, I think, is important to keep in mind in these cases. The leading case and the seminal case that seems to give a vendor an obligation apart from a restrictive covenant is an English decision, Trego and Hunt, decided in 1896. And that was a case where there was an admission of a new partner to a partnership, and there was an express term of the contract that should the partner depart, the goodwill of the business would stay with the original partner. After a number of years, the new, in quote, end of quote, partner departed and attempted to solicit the customers of the partnership, and the widow of the original partner sued for an injunction. One never knows how much that influenced the decision, but nevertheless, in a very interesting decision, there were a number of judgments, but the Lord MacNaughton and Lord Herschel wrote very extensive judgments, and they both agreed that in general terms, a person who sells a business is under no obligation to retire from that very field, and that no covenant is implied that the vendor won't start a new business in opposition to the business sold. However, on a very narrow ground, they argued that it would be unfair to permit the vendor, and I quote, to avail himself of his special knowledge to regain without consideration that which he has parted for with value. That, at all events, is opposed to the common understanding of mankind and the rudiments of commercial morality, and is not excused by any maxim of public policy. Now, I read that quote simply because of the strong emphasis it puts on this element of commercial morality. If you read the case in its entirety, you will see that in different judgments, in particular a judgment by Lord Herschel, there are really two fountainheads of the jurisdiction here. One is this concept of commercial morality, but Lord Herschel also seemed to feel that you could put your foundations on an implied term of the covenant, the concept that goodwill, when you sell the goodwill, there's an implied term that you won't depreciate the goodwill by your activities. And it's unclear from the case itself whether there's one theory or a blending of theories. In a number of more recent Canadian decisions, one of them is Jiffy People's Sales, which I've referenced in the paper, which is a British Columbia decision of 1975. Same type of facts. A sales agent sells a business and then attempts to appropriate for himself the single source of supply, the key customer that he was distributing, and the court followed Trego and expressly seemed to found their judgment on the implied term of the contract theory. In a more recent decision by Justice Cromarty, JLR Holdings, he went in the same direction. There was a sale of 6% of the shares of the business in conjunction with the purchase of other shares, but the person who had managed the business and had sold the 6% then went out into competition, and Justice Cromarty enjoined that activity, also referring to Trego and Jiffy. And while he doesn't express the theory, it seems that he was going along with the implied contract theory because that was the express theory in Jiffy. The last case in the chain that I wanted to mention was Commercial Transport and Watkins. Again, it's a 1983 decision of Mr. Justice Callahan, as he then was, and there were shareholders who were active in the business. A shareholder dispute arose. Two of the shareholders, it was a trucking business, two of the shareholders decided to leave. They sold their shares to other shareholders and then immediately went out into the trucking business and tried to do business with the customers of the plaintiff. The plaintiff was particularly vulnerable because more than 50% of their business came from two key customers, and these shareholders were out, or former shareholders were out aggressively soliciting them. Justice Callahan relied upon two lines of authority to enjoin the activities of the vendor, shareholder / former key employees. On the one hand, he relied upon Trego and the language which I referred to earlier about how it would be unfair to make use of special knowledge of the needs of the customers. But Trego, in my view, is a bit of a reach in this particular situation, simply because the plaintiff in this case was the corporation. The shares had been sold to the co-shareholders, and they weren't joined as plaintiffs, and therefore it's hard to see, one can see a duty owed to the shareholders, not so clearly a duty owed to the corporation. Now you may say that's technical, and it is. The other fountainhead of jurisdiction was Canaro, the seminal case about key employees, and while that dealt with the context of corporate opportunity, there's a general discussion about fiduciary obligations being imposed on top management, and these individuals clearly were top management. The blending those two lines of authority, Justice Callahan felt that it was appropriate to give an injunction, even though in this particular case the evidence was undisputed that the parties had sat down at the time of the sale of the shares and had protracted negotiations about a restrictive covenant. Ultimately, they didn't agree upon it, and the purchasers decided to go ahead even without a restrictive covenant. You might have a visceral reaction, caveat emptor, but notwithstanding, the court gave protection. The interesting thing, or an interesting thing about this decision, in my mind, is that in addition to restricting the vendor former employees from soliciting, there was also a restriction against contracting with any of the old customers. Now that clearly goes outside of Trego, because Trego made it clear that you could get, and there was an express judgment that said you can deal with your old customers provided they come to you. And Justice Callahan's order would seem to block that. And it would also seem to go outside of the Canaro concept, certainly as discussed in Alberts and Mountjoy, because the limitation had always been one of soliciting. It's all, in the fiduciary context, the test was the same. It's all right if the customers come to you, but you can't solicit them. The answer may be the anomaly of the facts, and that this particular business had but two main customers, and that there was a contract which the defendants had tendered for, but it had not been awarded, and therefore Justice Callahan was simply trying to plug that gap. And if that's the proper interpretation of the case, it may not be a great departure. If that isn't, it's certainly a major departure from the cases that I've referred to. The other area, so I guess the bottom line in that subject is, can a vendor be restrained in the absence of a restrictive covenant from soliciting? Clearly yes, but it would appear that the rationale is limited to vendors who are also active in the business and have some special relationship with the employees. If you're a passive vendor without involvement in the business, I would think the answer is still no. Turning then to the other area that I want to touch upon, and that is the interplay of restrictive covenants and wrongful dismissal, a case which I think caught the attention of most of us in the last few years is the decision of Her Honor Judge Feldman in Gerard Century 21. In that case, the plaintiff had been a sales manager of a real estate office for Century 21. She'd done very well. She was making good money. Her employer came to her one day and said, I want you to take a cut in your salary from $45,000 a year to $25,000 a year, and the implication was that if she didn't agree, bad things would happen. The employee left. She sued for constructive dismissal, and by way of preemptive strike, she sued for a declaration that her employment contract was no longer in force. I say preemptive strike because her employment contract contained a restrictive covenant for I believe 12 months that she wouldn't operate within a particular area, and of course she was operating in that area. The defendant, the Century 21 franchise, moved before Judge Feldman for an order restraining the carrying on of this business, and Her Honor dismissed the injunction application. Mr. Levitt was the lawyer for Century 21, but Her Honor did have other reasons. Judge Feldman reasoned that there was some doubt as to whether the contract which contained the restrictive covenant was still in force, and she was careful not to preempt the ultimate decision of the trial judge, but felt that there seemed to be reason to believe that the conduct of Century 21 showed that they were not prepared to be bound by the terms of the contract, and therefore she felt it would be unjust to enforce a contract against a defendant when the plaintiff wasn't prepared to be bound by the terms of it. And she relied upon a hoary old House of Lords decision to support that theory, being General Bill Post and Atkinson. Now, General Bill Posting and Atkinson was a case decided in 1909. Atkinson was an employee who gave a 12-month, who gave a restrictive covenant in his contract of employment, but the contract of employment also indicated that he would get 12 months' notice should he be dismissed without cause. He was dismissed without cause. He wasn't paid the notice, but the plaintiff still sought to enforce the terms of the restrictive covenant. And the House of Lords ruled that the restrictive covenant, being part of the contract, was rescinded, and they used the language of rescission because they said that they said the issue was, and I quote, whether the acts and conduct of the party evince an intention no longer to be bound by the contract. And because they viewed that the employer had acted, and again I quote, in deliberate disregard of the terms of the contract, Atkinson could treat the contract as rescinded. Now, I've emphasized this language of deliberateness because I think it's important when viewing these cases in context. Losing counsel in the House of Lords argued that not every case of that turns out to be a wrongful dismissal amounts to a repudiation, and that the covenants were interdependent. And those were, I think, prophetic arguments because they're echoed in more recent cases which have found favor with the House of Lords and certainly with the Court of Appeal of England. But on that day, he was unsuccessful, and I think the deliberateness may have been a factor. In my submission to you, there are at least two good reasons for viewing general bill posting in a very narrow context and not seeing it as having application beyond its particular facts. And one point is that general bill posting was a trial decision, and generally speaking, if you're going to found your case on a question of intention and deliberateness, that is a determination which is best left for a trial judge. On an affidavit and cross-examination, it's very hard to make a considered determination about intention. But secondly, in my submission again, and with great respect, the authority of general bill posting has to be regarded as perhaps dated when one has regard to the subsequent decision of the English Court of Appeal in Hong Kong Fur. In short, I think the law has advanced a pace in terms of determining which provisions in a contract are indivisible and which may be severable. Now, to the extent that deliberateness is a critical element of the general bill posting case, I would make two comments. One, in dealing with cases where cause isn't alleged, and one dealing with cases where cause is alleged. In cases where cause is not alleged, we've all had the problem you look at a set of facts and you make your best assessment. And we all know that there's no computer into which you can punch in the facts and get an incontrovertible reading as to what reasonable notice is. So that there are going to be circumstances where you make an offer, the offer you make is honestly, in your view, a reasonable offer. You're not intending to repudiate the contract, but through the retrospectoscope, a judge later on says, no, you fell short. It seems to me that situation is not deliberate. On the other hand, there are cases where the offer is so mean-spirited that it's nothing more than an attempt to use economic power and to hope that you'll starve the employee into submission. That may have an element of deliberateness. In cases where, similarly, there's a spectrum of situations where cause is alleged. There are some cases where there's absolutely no objective or subjective reason to plead cause. The employer just does it to hold the employee at bay, and there may be some question of deliberateness. But there's also a whole host of cases where the employer feels that they've got cause, and indeed cases where there may be some objective failure on the part of the employee to meet specified standards. I mean, we all remember the cases that were in vogue for a short period of time of near cause, where employers got a reduction because the employee didn't meet objective standards, even though it fell short of wrongful dismissal. So even in the cause area, it seems to me there's a spectrum, and it can't be the case that if deliberateness is the key, that every case of wrongful dismissal is a case of deliberateness. But it seems to me that more fundamentally, when you get to 1992, and with the acceptance that the Hong Kong Fur test has received in the English courts and in our courts, that there's one test now for determining whether or not a breach relieves the other party of its obligation to perform, and that's the test articulated in Hong Kong Fur, and that test is essentially this: does the occurrence of the event deprive the party who has further undertakings still to perform of substantially the whole benefit which it was the intention of the parties as expressed in the contract that he should obtain as the consideration for performing those undertakings. The language of rescission, repudiation, substantial breach, breach going to the root, really big breach, any combinations of the above are all now, I think, subservient to this single test which goes to the question: have you been deprived of substantially what you bargained for? And it does seem to me that there can be circumstances where there has been a long employment, so that the employee wasn't hired one day with a restrictive covenant, fired the next week, and the employer seeks to enforce the restrictive covenant, but the employee had the benefit of a long employment, 10 years, 15 years. There was a great deal of consideration for the promise of the restrictive covenant, but there was also a wrongful dismissal of a non-deliberate type. It does seem to me that having regard to the analysis in Hong Kong Fur, you can't say that that person has, that employee has not had, was deprived of substantially of the benefit that they hoped for when they went into the employment contract. Now, just coming back to Justice Feldman and her decision in Gerard and Century 21. First of all, I've known this judge for a long time, and it would personal reasons, and all, I mean, it would pain me to make any criticism of her, also in part because her husband is my dentist. But if there was ever a case which seemed to follow under the narrow ratio of general bill posting, a Century 21 struck me as such a case, because one can hardly think of a more fundamental breach than coming in one day and saying you've got to accept a 55% reduction in your salary. And while Judge Feldman was careful not to preempt the trial judge, it was clear, based on the admissions of the employer itself, that those facts wouldn't change at trial. The employer admitted those facts. So if there was a case of deliberateness, and if deliberateness still is the test, her case shelters under it. Now, Mr. Levitt, who argued the case, relied upon the decision of Poole, Tomlinson, and Saunders in the British Columbia Court of Appeal, which made reference to Hong Kong fur, and at one point gave approval to that line of thinking, but unfortunately I felt they dropped the ball a bit with respect, because they ultimately decided that since they went against the employer's the employee's argument that it was a case of constructive dismissal, and having accepted Hong Kong fur to determine other issues, they went on and said, but if this isn't a case of wrongful dismissal, other considerations apply. In cases of wrongful dismissal, they seem to accept the law in general bill posting. Again, I think both the Century 21 case and the Poole case are cases that are driven by their facts, and I would urge you that should this issue come up and you've got a better set of facts with a stronger emphasis in the argument on Hong Kong fur, a different result should apply if you've got an employee who's got substantial benefit from the employment contract. Those are the two topics that I wanted to discuss, and I thank you for your kind attention.
Sure. Just time for a couple of two or three questions. Let me ask the first one. Assuming you have a situation where the parties have contemplated some of these eventualities in the competition area through the form of a contract, to what extent do you think the courts will, and have they looked beyond that and said, notwithstanding the fact that they've only contracted to give this much protection, we're going to give more protection?
Well, I think that it's now quite clear that the courts will go beyond the protection that the parties themselves contemplate if they feel it is appropriate. I think that the recent authorities make that absolutely clear.
And what if it's within the same area? For example, they contemplated non-solicitation, but very specifically, to what extent there'd be non-solicitation? Will the courts go beyond that, even within the same area specifically contracted?
Well, I think that's a more difficult question, because there is a general policy that if the parties specifically address it and put their mind to it and contract in that area, that the contract should prevail. But if I were, having said that, I mean, that's the argument that I find more persuasive. Having said that, as if I were a betting person, I'd bet the other way and say the courts will still do what they think is just. That's the trend that I see in the cases.
Other questions?
Yes, one question. How does the issue of repudiation by the employer impact on the obligations of the terminated employee that arise not from his express restrictive covenants, but rather the fiduciary duties that exist in an employee while working for an employer or a lease? But if the employer repudiates the contract, what impact does it have on those fiduciary obligations?
Well, I suppose the answer to that question is the thesis of my paper. my thesis is, it, depending upon the circumstances, it shouldn't have an effect. The fiduciary obligation arises because of the relationship, and it isn't strictly speaking a contractual duty, but an equitable duty. And even if it were contractual, you have to look at the whether or not there's been a total failure of consideration to determine whether or not the two provisions are interdependent. So I think it depends upon the particular facts, but given that it's equitable relief, I would think the proper answer would be you do your equitable duty, and if you've suffered damages for breach of contract, sue for that and be awarded that.
Yes, one more?
Is there a question of double damages where the employee is relieved of his duty under the contract, and as an employee receives damages for wrongful dismissal?
Well, I must not be understanding the question.
Well, the employee will get damages for wrongful dismissal.
Right.
In addition, he has the right to go out and compete in breach of the covenant of the original contract, but as far as relieving it, is there a measure of double damage?
Well, I would think the answer then would, now that I do understand, and I apologize, the answer would be that to the extent that he's relieved of his covenant and compete, and can compete to the extent that he's successful, he has to bring that into the accounting by way of mitigation when his damages are ultimately assessed.
David, thank you very much. Administratively organizing this, let me introduce our next speaker, Mark Ellis, who is at Castles Brock. He received his Bachelor of Arts from the University of Western Ontario and his LLB from Queen's University, called to the bar in 1982. Mark's been a prolific author, writing several textbooks and numerous articles on wrongful dismissal and in particular fiduciary duties. He's an instructor of the civil litigation section of the bar admission course and is focusing right now on employment law and fiduciary duties. He's appeared as a speaker and chairperson in a number of programs, a commentator on television, including the La Corona Legacy, the CTV National News, Mandatory Retirement on the Shirley Show, and Rightful Dismissal and Wrongful Termination in the Andy Berry Show. And he seems to be providing us with a bit of a change of pace.
I want to thank my mother for that introduction. Sorry for screwing up having AV support. I know that always throws a kink in things. This is out of this month's Esquire. Shows a cartoon of a zoo setting with an almost extinct Homo sapien called the North American Middle Manager. Thought that was kind of fun. But since we're talking today about wrongful dismissal and related matters and just cause, I also got some enjoyment out of this one. Here's the chairman of the board wants to introduce the issue of absenteeism. I want to thank Howard for having me here today. This is really quite a fabulous panel, and I had to miss this morning because of complications. One complication I had some time back was I had to speak somewhere, and at the same time I had to be in court for a rather last-minute injunction. And it always reminds me of the best excuse for an injunction I've ever heard, and that was that the judge rolled in and said, anyone have to speak to any matters, and of course, any adjournments, and lawyer stands up and says, my lord, I gotta have an adjournment. My wife's about to conceive a baby. And the other lawyer, all prepared. My friend's a little anxious. What he means, my lord, is that he's his wife's about to give birth. Judge, without missing a beat, says, I don't care which it is, he ought to be there. I've been asked to talk today about fiduciary duties and beyond, really about fiduciary duties implied terms. If we were taking implied terms as the setting of employment law, of course, a lot of what David and Howard and others have told you today is that most of employment law tends to be by way of implied term. So I won't speak to all those issues. I'll try to relegate my remarks precisely and particularly to what I consider fun with fairness, as it were. The idea of all the F's that are now emerging in employment law, which is fiduciary obligation, fairness, fidelity, and all those other things that are easy to say but hard to describe and hard to capture. Starting with fiduciary obligation, we've had quite a run of luck with that area of law, especially in the employment law sphere, and that's because we have long ago with Canaro, which you all know so well and studied so hard, captured the idea that a fiduciary obligation attaches at least to directors and probably at that stage to senior employees, whether or not they're directors de facto or not. And that led to the imposition of the highest duty known to law, which is the fiduciary obligation, the obligation of utmost good faith. And as David pointed out just a little bit ago, once you move into the realm of equity, you move into what is a strange serpentine type of doctrine of law, and that is that all kinds of onuses change, all kinds of issues of proof are altered, and certainly the old rules of law can largely be said to be displaced by rules of equity and fairness and fidelity. The issue of how you get to demonstrate a fiduciary obligation in any particular setting was dealt with in this quite famous Smith case on another issue, Smith and Frame, Madam Justice Wilson. It's hard to see here, but the quote is basically that she decided there were three fundamental issues that gave rise to a fiduciary obligation in any given setting, including employment. And that was where you could find that there was a scope of exercise of discretion and power. The fiduciary exercises that power so as to affect the beneficiary's legal rights, and in the employment context, that's the employer's rights, or the shareholder's rights, the director's rights, and sometimes the rights of the creditors or the public. And lastly, and most importantly, due to the recent Lack case, the beneficiary is peculiarly vulnerable to or at the mercy of the fiduciary holding the discretion of power. And I think all of us in this room would say, well, that probably takes into account an awful lot of relationships. The fact is, it does take into account an awful lot of relationships, and that's why, like negligence, there is no limit to the availability of fiduciary obligation in any given relationship. However, to say it again, we have established quite dramatically in employment law that it attaches quite regularly to at least the upper end of the hierarchy in employment law. When this case when the first major case, the Canaro case, came before the court, Laskin then said this quote, and the last part is of importance to us. It didn't matter to the court in that instance that the directors were not truly directors, or that there might be some fault in the appointment of directors, or that in law maybe they didn't occupy that director's obligation or that director's post. Rather, they were simply senior enough, regardless of their titular role, to be responsible for running the corporation or making the corporation vulnerable to the power that they wielded. Therefore, the fact that they may not have been directors was really quite irrelevant. And that was really quite the start of a precipitous development over the years that we'll have a look at now. A couple of years ago, the special lectures were run by David Roebuck and others with respect to fiduciary obligation. And the former Chancellor of England came to speak. It was very enjoyable. And he had some great phrases to use. One of them is in this quote from the special lectures. And he was talking about how remarkably he found it that Canada had developed into a land of fiduciary obligation. He said, in England, we know what fiduciaries are. You can actually, sometimes they even have F's on their head. It's easy to point them out and easy to find out what they are. They are relegated to the higher echelons, directors, and that type of thing. He said, however, and at the bottom, this is a great quote, talking about the expansion of fiduciary duties in Ontario and Canada. The traditional beauty of a land flowing with milk and honey is marred by the realization that it could be very sticky. What a land awash with fiduciary relations, he says, is Canada. The reason he found that so not so much disturbing, but interesting is the way he phrased it, I think, benevolently, was that he was aware of some of the statistical data on the development of this theory in North America. Since 1988, we've had, and it's beyond this now, but we've had reported cases in 1,280 here, in Australia 900 and some, but in the US 31,716 cases on fiduciary obligation. So we think, he thought that it was very impressive that we were busy being the land of milk and honey, but he hadn't turned his eyes southward yet. Those of us who read, all of us who are reading the papers from the States know that fiduciary obligation and the responsibilities of directors, senior officers, is quite extraordinary down there, and perhaps we've curtailed it even beyond them. But what Canaro did really was open up a Pandora's box, and the way it did it was to say, we no longer stick to simply directors' responsibility, we stick to those people wielding the power of vulnerability. And if that was the case, vulnerability, if found extant in any circumstance, could give rise to a conclusion of fiduciary obligation. So we had some graphical depiction like this going on. 1970, it was directors. 1974, Canaro, it was top management and directors, and it went on from there. And you can see from this graphical depiction that it went upwards and upwards through 1986 and thereafter, where we had all these different definitional responses to what is a fiduciary, which ironically went right down the ladder to the very bottom. We had from top management to senior management to employee of a small business, even though a mere employee, because of vulnerability of that small business. Then to employee of a vulnerable business, whatever that is. I think that's O and Y. Key personnel, which everyone would say any given moment that they are. And then finally, key to a department only. And that case, the last case at the top of the graph, involved a Hudson's Bay store that had a small department that was run by a manager. And that manager was responsible for having a client list of people who needed glasses. And when that individual got tired of being an employee of Hudson's Bay, he decided that he could go and open up a small little store in Winnipeg and perhaps enjoy the clientele he'd developed over a 13-year period. Hudson's Bay said, oh, no, you don't. Those are our clients, and you are a key employee to our particular department. Therefore, you're a fiduciary. Therefore, you owe the highest duty known to law, and therefore, you cannot go ahead and do what you're intending to do. And by the way, you'll lose your $22,000 a year if you do it. So went off and did it. The court, Manitoba's Queen's Bench, granted an injunction against his carrying on business in competition. We went from Canaro at the very top of the pillar quite quickly to the very bottom to being a key employee to a very small department. It got even worse than that. In my opinion, it's worse because it almost demonstrates it being out of control, to cases that Howard and David would tell you about, which are simply cases involving clerical workers who, because they are near the filing cabinet and may have the key, therefore have placed the entire business in a vulnerable position and therefore occupy a fiduciary obligation. And that just simply isn't right. That means we've gone too far. Happily, the trend is backing its way back up the ladder, and the reason it's doing it is a very germane case, and that is the Lac Minerals case. And what's happened with that is that precedent-setting case really bolstered the law of confidence and confidentiality as a tortious document as opposed to an equitable document. And so we no longer have to move to positions of trust law in order to overcome problems of confidentiality, the stealing of secrets, and the misappropriation of corporate opportunity. What hasn't changed, though, is that if you can find yourself in equity, there's no question that the strict ethic of the situation involves a very powerful remedy in law. That's why it's been so attractive to all of us for the past at least 10 years, and more particularly the past 4 or 5 years. The reason is that if it's premised in equity, which it clearly is, and you can convince a judge that you are in equity, then that judge has the power of any remedial power available in law or equity to remedy the problem. The other issue, as I addressed at the very beginning, was that strict ethic also attaches to it strict controls on evidence, onuses, and burdens of proof. And in the circumstances, the reverse onus creates a problem for the party alleged to have been doing the wrong rather than having the party alleging the wrong proving it. In terms of the issues relating to fiduciary obligation for employees, we've chatted briefly about the status, how to decide whether the person is in a fiduciary obligation. We've run through the tests and the present confusion. But in terms of the obligations of the employee, we are predictably usually dealing with employees who depart. And the last question asked of David, I think, was relating to how you might deal with issues of repudiation by the employer versus attempts to compete by the employee and issues like that. And I agree wholeheartedly with David that really the equities prevailing will typically consider that the employee of breaching a fiduciary obligation ought not to receive any relief from the fact that the repudiation by the employer has occurred. The only narrow focus that I think David and I would probably agree about on that is that livelihood is a very dramatic defense to a breach of fiduciary duty allegation. In other words, if the fact is that the employee, after departure for whatever reason, but particularly in cases of termination without compensation, finds herself or himself unable to support themselves, then typically the equities fall fairly clearly in favor of the employee. I touch upon in this list here the common law confidentiality, which I want to turn to in a minute. We also have, as David points out, the restrictive covenant issues, which are contractual in nature as opposed to equitable in nature. I think we all, as employment law lawyers, sponsor the idea of contracts that can increase predictability amongst our clients in terms of enforcement or in terms of what will be enforced against them. However, it's kind of haphazard, the development of the law, so we still find that you can not only have a restrictive covenant, but even if the restrictive covenant is found to be inoperative, it's quite clear that the case law supports the superimposing of a fiduciary obligation or a tortious a remedy pursuant to tortious breach of confidentiality if the covenant doesn't stand for reasons of law. I've been asked today, of course, as I indicated, to talk a little bit more broadly about not just the fiduciary obligations, but rather the way the law is developing. And I think the panel this morning, although I'm sorry that I missed it, I'm sure expanded dramatically on where we're going with these areas. And I jotted down a few points that I could canvass very briefly. It is very clear, and oh, I forgot to mention, my paper is here. It's just out there. So they're going to mail it to you, as I understand it, just to save money, I think. Anyway, my paper delves into the issues of good faith and where we're really going with the issue of fiduciary duties, fairness, and fidelity. It'd be my thesis that what really has happened with the area of fiduciary duties is that it's what I call the tail wagging the dog. Clearly, when the law stands up and says some remedy has to be attached to this, the courts will find a remedy, and it's very easy to fix upon fiduciary obligation. Vulnerability can always be found in any given circumstance, especially one as tight-knit and close quartered as an employment relationship. I think that the law is developing and should develop into more an issue of good faith as an implied term of all employment relationships. And if that was true, and if that's where we could go as a theory of law, then we wouldn't have so much need for recourse to the fiduciary obligations of quasi-trust. I think it's happening, and it may be happening a little bit in disguise. We've already seen it historically operating when we see such things as restrictive covenants being turned down for contra proferentum reasons to be read against the employer, or being invalid for being too much an infringement of the the rights of the individual. That's really, to my mind, good faith working backwards in terms of legal constructs. Sooner or later, I believe, will move just dramatically to saying, well, it's in breach of good faith between the parties. Ironically, in a commercial way, we've already codified that internationally. They're already operating, as most of you know, laws relating to international commerce that require that all contracts have an implied obligation of good faith between the parties. That, I think, is fast becoming the way we deal with employment issues. We deal with it that way in the following ways, as I see it. The pre-employment representations that are now becoming actionable in terms of the law. That being the employee who must submit resumes that are proper, not misleading, and are truthful. Pre-employment fidelity, which is the subject of much case law relating to the obligation not to say you have an MBA if you don't. And again, that's actionable. The employer has an obligation to use correct hiring procedures. That's both common law and statutory. Human rights concerns, employment standards concerns, and of course the common law in terms of what may be asked, etc., by the employer. Again, fair representation of the position to be held. Otherwise, it can be a pre-employment misrepresentation, which I think is the same thing as good faith amongst the parties. And also, if advancement is promised, then I think Howard and David would be the first to say that we probably have a breach if it doesn't come to pass, although most employers are clever enough to sponsor the vagaries of maybe it'll happen if you perform adequately. But if it's a certain warranty, then the failure to provide the advancement is probably an actionable issue. Employment issues during employment include an obligation of fidelity, which the British Columbia Court of Appeal has considered to be a concept of law now, that during the employment fidelity is owed, fidelity being the obligation to exercise good faith towards the employer. Likewise, with performance criteria, I believe that good faith is demonstrated by the stuff of wrongful dismissal and just cause, working both ways. If we introduce such concepts as remedial discipline before we can terminate for just cause, we are in essence saying both parties have to exercise good faith before termination can take place without compensation. The employer owes during the employment fair wages pursuant to statutory obligation and common law, fair working conditions pursuant to statutory obligation and common law, and constructive dismissal can really be seen to be an employer that abrogates that responsibility dramatically in any of those spheres and others. Likewise, I believe that the court's reaction to good faith in terms of termination of employment is the obligation implied, as I've been asked to speak about, of notice and severance. And we've seen as late as the case that Howard argued that is the topical case for today at the Supreme Court of Canada, that we have the court saying that the purpose for notice is to provide adequate compensation, and that the public policy issues behind notice are that you can't nickel and dime your way around notice by having some kind of contractual obligation that doesn't work. Post-employment responsibility is primarily what we've talked about in terms of fiduciary obligation. In addition, we have, as I said, the imposition of fidelity, which the Court of Appeal of British Columbia and now Saskatchewan, not yet Ontario, have said are a fabric of the employment relationship, which lasts not only during it, but also after it. So that we don't have to reach into the fiduciary envelope to find this utmost good faith issue, the argument of trust. We can simply say that if you go and you abscond with even the stuff of intellectual property, it may well be a tortious issue as opposed to a trust issue, and available for all employees and all employers. Non-competition is the stuff, as I see it, of typically fiduciary obligation, fidelity, implied obligation of good faith, and then lastly, restrictive covenants, which we've discussed earlier. Lastly, if you look at the post-employment responsibility of good faith of the employer, it's my thesis that, again, severance is that's the stuff of good faith, and also the now emerging issue relating to whether or not it's the obligation of an employer to provide fair comment regarding the employee's ability to a third party. And we all know that that's been litigated rather intensely with varied degrees of success. I believe, subject to comment, that the law now stands that fair comment is absolutely the right of the employer, to the extent that only where malice exists is it actionable. But there is the rumblings of case law that's developing and is very dramatically developed in the United States and the United Kingdom, saying that the reverse is true. Unless you're motivated by fair comment, in fairness to the employee, malice is quite irrelevant to making it actionable in terms of comment by an ex-employer. Those are my thoughts about how the law is superimposing fairness and implied terms into this environment which has historically required us to find a trust component to the relationship before being able to dramatically move on issues in the court. And I really don't wish to take my remarks any further. My paper is full of comments relating to case law and otherwise that might support the proposition of the developments that way. But before I end, I have to tell another bad joke. This lawyer and a pope show up at Heaven's Gate, and St. Peter says, "Welcome, I'm going to show you to where you're going to be staying for all eternity." And they show this lawyer a big hill, Casa Loma, beautiful place, servants and everything else. And the lawyer says, "That's fabulous, thanks very much." Drop off, take the pope down the street to a suburban area and to a bungalow. And the says, "Here's where you're going to be, Mr. Pope." The pope says, "I don't understand this. I'm a man of the cloth. That's a lawyer there. You gave him Castleham. You're giving me a bungalow?" And St. Peter says, "Well, we get a lot of popes up here." Thanks for your patience.
It was interesting that Mark wasn't here this morning, and that notwithstanding that, he commented on the very same thing that Madam Justice McLachlin did when she talked about this doctrine perhaps entering here, but certainly that's becoming more pronounced in the United States, of good faith bargaining, which you'll remember, in good faith contract. And what I find interesting, because so many individuals will come to see any of us and will have concerns that, of course, I think or have thought, don't found legal cases based on the present substantive law, such as, I'm not being dealt with in good faith, I'm not getting promotions that other people are, I'm not getting good evaluations, I'm not getting the same increases that I'm entitled to. Now let's assume they're accurate in their apprehensions, first of all, and let's assume that it has nothing to do with any of the prohibited grounds pursuant to human rights legislation. Do you think at this point in the development of the law there's some basis for an argument to give them a cause of action based on the failure of the employer to utilize good faith during the currency of the employment relationship?
I think it would be very brave to suggest we could simply knock off a statement of claim based on breach of an implied obligation of good faith, but I think all three of us have experimented a little bit with the expansion of remedies such that we're not very brave, we simply have it as paragraph sub C. And I certainly do that. It's, breach of fiduciary obligation and trust, breach of an implied doctrine of confidentiality, breach of a tortious breach of good faith as implied by the circumstances of the relationship. And frankly, because of the tail wagging the dog, in my opinion, the courts, and because they're not required to really state the nature of the relief necessarily, I find that the courts are always stepping up to bat and hitting a home run on the remedies, but they aren't necessarily being, I hesitate to say it this way, honest with the reason they're getting there. So I think the development will continue.
Mark, I agree with what you say, and let me ask you to be a little bit more brave for a moment. Do you think it might be coming?
Yes.
Okay. Thanks very much. And, well, any other questions, first of all? Let's.
Just to carry that thought a little bit further, I've started thinking of this when Madam Justice McLachlin speaking about the idea of good faith becoming an idea of currency is coming. Is that if you carry that along, and I don't think I'm stretching the concept to say that the employee is increasingly going to have fiduciary and equitable duties and fidelity, that the employer is also going to have increased duties to treat them civilly and fairly on termination, which makes me think that if good faith does come back, then the Morgan store has to be reopened again, and that punitive damages for mental distress are going to have to be addressed again. I mean, they were blocked out because that's not part of the contract, but if there's going to be good faith, it's going to have to run both ways, and it's going to have to deal with termination procedures. Do you have any comments on that?
My only comment would be that where I've seen successful allegations regarding punitive damages, accelerated damages, exemplary damages, they have always been well beyond the legal fiction of pretending that the parties had put their minds to it at the inception of the contract, and therefore that they were predictable damages flowing from the breach. I don't think any court has done anything other than pay lip service to the fabric of that pleading, and then from there said, these are the circumstances where a penalty ought to be implied, or applied, I should say. I don't know if David and Howard agree with that, but that's certainly my theory on it.
Well, that seems to have been where they've developed so far, but I guess, as this gentleman's suggesting, if you impart a good faith concept, perhaps more tortious remedies would flow as well. Perhaps.
I think that the judiciary will still be very cautious with it. It's just that my own particular problem with it is the labeling. I'd like to see it labeled appropriately, and the reason for it. So I agree with you. But I don't think it'll be a floodgates argument necessarily.
Other questions?
Seems it's getting more and more difficult if you're acting for an employer to draw an agreement that's going to stand. Perhaps with all this area opening up, split pay bargaining, how can you assure your client that he's got a good contract? Are you negligent if there's an action on the contract struck down in the process?
I mean, I always thought it was a funny quote at the Supreme Court of Canada in Lac Minerals when one of the advocates said, you know, what we've confused here is that the court is trying to apply morality to the law and they have no business together. I thought that was an interesting remark. I guess I would say that my comment to you would be, I don't think it's a negligence issue for lawyers. I think it is a tough battle to overcome all of the issues relating to what is good faith. But it's a whole lot harder to figure out what is a fiduciary obligation and why would it attach to the cabinet girl who has the key. So I think it's a fair comment. It's becoming very difficult to have a perfect agreement. On the other hand, I don't know that it's all that difficult when you smell it to understand that you're into bad faith versus good faith. And there are a lot of people who would simply tell you it's a smell test, with all different sized noses.
Other questions? Mark, thank you very much.
Pleasure.
Let's take a 5-minute break, and please, those of you who have to leave, please fill in your evaluations for the purpose of the faculty.